Hi, everybody. Hi, everybody. I'm really excited to be here and share a little bit about Start Small, Think Big. We are a national nonprofit serving small business owners with financial, legal, and marketing. And we are able to do it very similar to the work that LCCR does. We match you with an expert in one of those areas. And we do have eligibility requirements to apply for our services, but we also have educational webinars where those are open and available for everybody to use. You don't have to be a client of ours to access them. We record all our webinars and make them accessible to you all. So what we do is we connect small businesses with high potential who might not have access or resources available as easily. So one of our things, for example, in our finance, what we're able to do is projections and planning, helping you with your bookkeeping systems. In marketing, we focus on digital marketing, so branding for your social media, website audit. For legal, very similar to the work that LCCR does, we focus on transactional legal support. We do want to support those that identify as people of color, women, LGBTQIA, immigrant, veterans, people with disabilities, formerly incarcerated folks. And what we ask through the application is your household income, your assets, and at least $500 in sales in the last 3 months. So I'll share more on our website, I'll share our website and I'll share the application link if you're interested.
Thanks, Cristal. Thanks to all the attorneys from Wilson Sonsini. Feel free to introduce yourselves as well. We thank you so much for the support of your presentation today.
Great, thanks. I'll go first. My name is Hale Melnick. I'm an associate in the Privacy and Cybersecurity group at Wilson Sonsini. Focusing primarily on digital health issues, but have written a very large number of privacy policies at this point, and we'll be handling the privacy policy segment of this presentation along with Yeji, if you want to introduce yourself.
Hi, I'm Yeji. I'm also an associate in the Privacy and Cybersecurity group. I focus primarily on state privacy laws, and I have also drafted a handful of privacy policies. And just excited to be here. And I'm based in the San Francisco office.
Hi, everybody. I'm Christina Wang. I'm Associate Attorney in the Technology Transactions Group at Wilson. And so we advise clients on all kinds of commercial transactions, including, for example, collaboration agreements, development agreements, partnerships, distribution or reseller agreements. We also advise clients on all kinds of intellectual property related questions or issues, including any license agreements that involves IP. So I will be handling the terms of use and section of the presentation, and at the end, I'll provide some high-level tips on intellectual property law and how to manage and protect your IP. So I can start. So before we dive into the presentation, just a disclaimer that the presentation is intended to be informational. These materials are offered as an education and learning experiences. There is not a substitute for obtaining legal advice from an attorney licensed or authorized to practice in your jurisdiction. Review of these materials does not create an attorney-client relationship. So before diving into term of use, we just want to provide some high-level comments on why it is very important to have an attorney review or draft your term of use and privacy policy. So first of all, terms of use are contracts, and what that means is that if properly drafted and implemented, they are a binding agreement between you as the website owner or app owner and everyone who accesses or uses your website or app. So I would really, yeah.
Oh, sorry. And then, so in terms of the privacy policy, it's a little bit different. It's not necessarily contracts, but it puts users of your website, your apps, and your other services on notice of your privacy practices, essentially how you collect, use, and share that information. So this is more of a notice, whereas the terms of use is actually a binding contract.
So for startup companies and small business, it's really important to get customized terms of use and privacy policy. I really want to stress that you should not copy paste terms of use or privacy policy from someone else's website or app, because they may not be applicable to your product or services. And secondly, ambiguous terms are always construed in favor of the non-drafting party, meaning that if you copy and paste terms of another company and there is an ambiguous term there, and if your end user sues, then you lose the benefit of the doubt because you are the drafting party. You are deemed the drafting party. And later on, if you decide to bring on investors or buyers to sell the business, reviewing your existing terms of use and privacy policy is likely part of their due diligence process. So we really want to make sure that these are done right at the beginning.
And then relatedly with the privacy policy, that really is a document that should be tailored to your specific privacy practices. Even if your competitor has a similar product, you may be using the data in many different ways. And to the extent that you are describing your privacy practices in a way that is not accurate to how you collect, use, and share personal information, that can lead to a number of problems down the road for you, including government oversight issues.
So term of use sometimes also called terms and conditions or terms of service. They're basically the same thing. And as mentioned, when properly drafted and implemented, they are legally enforceable contract, and they will bind any user of the website or app to the provisions set forth in the terms of use. So unless you're providing a purely static informational page, then you should really maintain a terms of use and a privacy policy on your website or for your app. So for example, if you sell any product or services on your website, or if you have any interactions with users of the website or app, then you should really have a terms of use and privacy policy if you collect any information from your users. So at a very high level, the purposes of having a set of terms of service are, first of all, to set user expectations about how the website or app is intended to be used. Very often the terms will have a section on service overview and some other sections that describe how users can and cannot use the services. And secondly, terms of service should provide guidelines that govern user activities on the service. So for example, can users upload or post content to the service? Can they directly purchase products or services through this or services through the platform? Or can they interact with other users on the platform? And also the terms will establish the consequences for violations of those guidelines. Another task or purpose for the terms is to establish mechanism to resolve disputes that may arise from the terms or from the use of your service. So for example, if you and an end user have a dispute about payment, how should the dispute be settled? And last but not least, this is really important, the terms should limit your liability in connection with any legal claims that could arise. And this is usually done through liability caps, and we'll dive into that later. So just some key topics to address in the terms of use. I'll just first give a very high level overview of what each of the sections should cover, and then I'll go do a deeper dive into some of the sections that are a bit more nuanced. So first, age limitations and other eligibility requirements. This is really straightforward. So basically you want to set appropriate age threshold for your services. And there's one important point to keep in mind, that minors under the age of 18 cannot form legally binding contracts. So what that means is that they can repudiate the contract and get a refund for the services. So basically meaning that they're not bound by the terms of the terms of use. And there could also be other issues when minors are allowed to use the product or services, primarily privacy concerns, which Hale and Yeji will touch upon in the privacy section. Beside age limitations, You could also have additional eligibility requirements, for example, that the users have not previously been banned from the service, or if they are acting on behalf of an entity, then they have the authority to do so. So next, the terms should describe all the pieces of information users may provide via the services. For example, if the information they need to submit when they register for an account or when they fill in a contact us form. And next, the terms should also clearly establish IP ownership in the different types of materials available on the website. And I will go into more details later on that. So prohibited conduct section is also very important because it describes all the actions that you don't want users to take or make, including, for example, using the website for illegal purposes or upload any content that violates a third party's rights, or copying content from the website using web scraping or web crawlers. If you allow users to upload or post any kind of content to the service, for example, if the website includes a comment section or review section where users can see the content posted by other users, then your terms should also address user-generated content and how you comply with Digital Millennium Copyright Act to take advantage of the safe harbor provisions. So a quick overview of DMCA safe harbor provisions. So they recognize that it is very difficult for online service providers to screen each post by a user to make sure the post does not infringe a copyright. And the provisions basically limit the liability of the service provider under certain circumstances, including hosting content at the direction of the users, where the service providers do not have actual knowledge of the infringing materials. But there are certain conditions or requirements that you have to meet to claim protection under the safe harbor provisions. So for example, you have to have a designated copyright agent who can receive infringement notices from copyright holders, and you have to implement a notice and takedown procedure for allegedly infringing content and allow users to challenge improper takedowns from the platform. So next, indemnification, disclaimers of warranties and limitation of liability. These are probably some of the most important provisions in the terms, and what they do is primarily risk shifting or risk allocation between you and the users. So in other words, when something went wrong, these provisions will provide who should bear the risk or costs or damages. For example, if a user uses your website or app for illegal purposes or post something to the service or post to the app that is infringing a third party's IP right, and you are sued by the third party for such infringing content, then you could ask the user who posted those content to indemnify you or reimburse you for your legal cost if you have a properly drafted indemnification clause in your terms. For governing law and dispute resolution, they basically address how a dispute in connection with the terms should be resolved. It's very important to keep in mind that if you are selling products or services directly to individual consumers, or if you have a lot of cross-border arrangements, then we typically recommend choosing arbitration over litigation, because in the B2C content, arbitration is likely more efficient, and typically you include a class action waiver in the arbitration provisions so that individual consumers waive their rights to participate in a class action. Sometimes the terms also need to contain a section addressing modifications to the terms, but I will come to it in a bit. And then lastly, if you make your app available on Apple App Store, then there will be additional terms that you need to include in your terms to meet Apple's requirements. So the most important element of a terms is making sure that users actually accepted the terms and that the terms are binding, meaning legally enforceable and against the users. The rule of thumb is that the more you can show that customer or user was provided notice that the terms of use exist and was given an opportunity to review the terms before they access or use the service, then the more enforceable the terms will be. It is even better if you require the users to take an affirmative step to show their consent to the terms. And also you need to make sure that users can access copies of the terms of service and privacy policy at all the time, including via hyperlinks on your website homepage. So to acceptance of the terms, the common practice for websites is to simply provide a prominent link to the terms, for example, at the bottom of the homepage, and include language in the terms, which is usually at the very beginning of the terms and in all caps, saying that the terms are binding agreement and access or use of the website or term constitutes acceptance of the terms. And as mentioned earlier, it is even better if the users are required to take an affirmative step, which could be done via a click-through terms, where the users are required to check a box with text saying something along the lines of, by signing up for an account, I agree to the company's terms of use, acknowledge the privacy policy. And the terms of use and privacy policy should be hyperlinked and in different colors. So if you would like to update your terms or modify the terms after it was published, and then similar considerations apply. So for material modifications, meaning anything that you would like to enforce against users, including, for example, a change to the age requirement or to governing law or dispute resolution procedure in the terms, then you need to provide users notice of the changes. This could be done by posting a highly visible notice on your website homepage or by sending an email to all your users. For minor updates, they will be incorporated into the terms without notice. So, but the best practice for modification of TOS is always to include language in the terms, reserving the right to update the terms from time to time, and that specify that ongoing use by user constitutes agreement to the changes. So another important section in the terms of use is the privacy policy section. So if your website or app collects any information from or about individuals, including their names, address, or birth date, then the terms should link to your detailed privacy policy. And Hale and Yeji later will cover that what information need to be included in your privacy policy. To intellectual property elements, as mentioned earlier, your terms should address IP ownership for all the materials on your website, including any original work, logos, images, text, or original software code. The terms should specify that between the company and the users, the company solely owns all the IP in those materials, and users should not copy or use those materials without your permission. And note that this is assuming that you don't have any user-generated content on your website or app, because if you do allow user-generated content, then we need to have a separate section to address the content that are posted by users. So more to user-generated content, it really covers everything that is uploaded or posted by a user to the website or to your app or to your platform. So for example, user comments that are visible to other users, or images or photos or products that photos of products that they purchase from your platform. If you enable user content on your website, then first of all, you probably want to have some rules or guide rails around what user content is acceptable and what is not. You want to protect the intellectual property rights of users and third parties, and part of this is comply with the Digital Millennium Copyright Act to have a notice and takedown procedure for infringing materials posted by a user. And aside from copyright infringement claims, there could also be other risks associated with user content. For example, users can post content that infringes someone else's privacy or publicity rights, or that potentially damages someone else's reputation that could subject the user or you to defamation claims. And what the company usually do here is to include in the terms representations and warranties by the users that what they post will not infringe other people's IP or privacy right, etc. And finally, be aware that there could be some risks associated with content moderation if you want to moderate user-generated content. And lastly, I just want to revisit a few sections that were mentioned earlier. It is crucial for startup companies and small businesses to properly limit their liability exposure. This is typically done by having a liability cap at the maximum amount of costs or damages that you need to be responsible for toward the user. So for example, the cap can be a fixed amount like $100, or it can be calculated based on the fees paid by a user in a certain period of time. So for example, 12 months, the fees paid in the 12 months period before the claim in question arose. And for dispute resolution, it is crucial to ensure home forum, meaning that any lawsuit related to the terms or your services should be brought in the state where you operate your businesses, so that you are not required to fly to another state to defend a claim. And in connection with that, the terms should specify which state's law governs, because the laws may vary from state to state. And typically, what you want is to set the governing laws to be the laws of the state where you operate your business. As mentioned, if your service is direct to consumer, or if you have a lot of cross-border arrangements, for example, if you sell to consumers located outside of the US, then arbitration is likely a better alternative to litigation. Hale and Yeji will touch upon this last point, but so I will just quickly flag that if your business operates internationally, so for example, if you target markets outside of US, or if you collect information from individuals located outside of the US, then you may need to comply with international privacy laws, especially if you have users located in the European Union. So finally, I just want to quickly touch upon some of the unique issues for selling products or goods on your platform, and some of these are not necessarily limited to direct sales. So it's essential to describe your sales policies in your term as well, including any refund and return policies, and when and how will the goods be delivered. And if you have a subscription service that automatically renews, for example, from month to month or from year to year, then it is crucial to set out your cancellation policy and give users notice of the recurring nature of the service before they sign up for the service, and remind them before any subsequent renewals. And in addition, you may also need to address collection, processing of payment information or other customer information. And you probably also want to disclose the fact if you use a third-party processor to process payments. And finally, note that there may be additional laws that apply to your sales activities. For example, if you process transactions, then you may need to comply with the payment card industry data security standards, especially some security requirements on how you collect, store, and process personal and payment card information. And for direct sales, the FTC merchandise rule may also apply, which requires you to make prompt shipment to users. So that's all I have for the terms of use section. I will hand it over to Hale and Yeji to cover the privacy policy.
I had a quick question before you move on. I think a lot of the businesses are really engaged in like their direct sales piece, and I found that really interesting. I wonder if you can say more in terms of like, are there certain templates or any type of like, where can they access some of this language to include on their websites for direct sales?
Yeah, so as a starting point, I would look at the company's website who provide who provide similar services or direct sales, and look at their terms and see what they include. But there's always a caveat that you don't want to just copy and paste other companies' terms of service. And so I would just always because like the depending on the product or service you're selling to consumers, the terms may need to be customized because there's different considerations applied to, for example, if you're selling physical goods compared to services. So I will just always consult with attorney, and the terms should always be customized to your fact pattern.
And just also out of curiosity, when it relates to like sales of food, for example, is there anything additional that folks need to understand or look out for?
Yeah, so I'm not an expert in food, but or direct sell food, but I think there's some regulations applies to, like, if you're just direct selling food, and there's could be some additional laws that apply, and that should be addressed in the terms.
Got it. Thank you.
Yeah.
Okay, so we will move on to issues related to privacy policy. So we'll first start with what is a privacy policy. So when you visit a website, you've probably encountered a link located on the bottom of the website footer that either says privacy policy or privacy notice. Technically, a privacy policy is an employee-facing document, so that's supposed to inform the company's employees of how their information is used by the company. Whereas a privacy notice is really for the consumers, that it is public facing, that describes how a company collects, uses, and discloses personal information of its consumers. But most companies refer to their consumer facing notice as a privacy policy. So we'll just stick to that term throughout. And to briefly talk about the structure of a privacy policy, the three pillars of a privacy policy are collection of personal information, and how that personal information that's collected is used, and to whom that is disclosed and for what reason. And I wanted to talk a little bit more about the collection part of personal information, because everything in the privacy policy and what's disclosed is kind of predicated upon collection. So you can divide collection of personal information into three categories. The first is what the users would provide to you, typically in a website context. That includes things like when the user registers for an account to use your service, they would provide email addresses or their name or their username. That would be the kind of information that the user would provide to you. It also includes email addresses when you sign up for a newsletter. And if you have like a support function, customer support function, or chat boxes, any content or messages that's included, that's provided by the user would be covered under this category. And then the second type is what's automatically collected by you, the company, when the user visits the website. And that includes things like Google Analytics trackers, if you have them installed, and that practically collects users' use data, things like when they visited the website, the content that they viewed, and how long they viewed it, and the pages that they clicked on. And then lastly, the third type of data that's collected is data collection by third parties, and the information that you would receive from the third party. An example of this can be like single sign-on options, when you allow users to sign up using their Google account. And then if you would receive certain information from Google about these users, that would be covered as an example of personal information that is received from a third party. And then my colleague Hale will talk a little bit more about privacy policy best practices.
Could you get the next slide, please? Great, thanks. So why do you have a privacy policy? There are a number of states that have laws that require you to have one. It's also to comply with the Federal Trade Commission, which is the federal agency that oversees essentially kind of like the umbrella for privacy in the US. In the US generally, we have like a what's called kind of like sectoral privacy laws. So we have we have privacy laws for health information under HIPAA. We have privacy for securities. We have privacy for children. FTC is kind of the umbrella, and that's kind of the main thing that you're looking to cover when you're when you're writing your privacy policy. There's also a number of states that have recently, in the past couple of years, passed comprehensive state privacy laws that we'll talk about in a little bit more detail right now. And the list is ever expanding, but I think California, Colorado, Connecticut, Iowa, Virginia, and Utah. There are a number of other laws pending in state legislatures. Pretty much all these comprehensive state privacy laws have threshold requirements, which for a startup company, you're probably not going to be meeting in the near future. But something to keep in mind, because those more comprehensive state privacy laws have much more stringent requirements for what you need to include. So as you grow and hit that one day $25 million revenue threshold, for example, then you need to be thinking about how you're using data and what you're saying about it on your website or apps and your other services. Also, just to keep in your mind, if you are a small startup and you're thinking about getting acquired or something like that, you may go through a diligence process. You will have to disclose to your privacy practices, and you don't want a misuse of data to hold up a deal or an acquisition or something like that. So to the extent that you can kind of start on the right foot and be as accurate as possible, that's only going to help you. Additionally, so even if there are, state requirements, it's best to be as broad and comprehensive as possible, no matter where you're operating from. We'll talk about this a little bit later, but to the extent that you're US focused, and people can visit your website from anywhere in the world. That's how the internet works. But to the extent that you're not, providing your services in French, and you're not accepting, a yen or other types of currencies, you can kind of just focus on US privacy laws, US requirements. The kind of targeting is kind of how we think about, who you need to address this privacy policy to, and who's going to, what kind of regulators are going to be looking at it. So website owners can be liable for lack of compliance with their own privacy policy. This is really important. You don't want to say something that's not accurate, either affirmatively saying something or an omission of something important. And also, when you're drafting this, always you want to be as accurate as possible, but also you don't want to unnecessarily box yourself in. So, you want to be accurate and tell people how you're going to be collecting, using, and sharing their information, but you don't want to be so specific that you can't, use their personal information for a way that would seem to make sense and be reasonable, but because of the way you wrote your privacy policy, you can't. A lot of clients or companies in general get in trouble by trying to say too much. So you need to be thinking very carefully about your language. Probably the biggest issue that we come up against with a privacy policy that's not accurate, or a company that's not following its own privacy policy, would be an FTC investigation as an unfair, deceptive acts and practices under. And that is something you really want to avoid. It can be very costly and expensive, and it can greatly curtail what you can do in the future if they do investigate you and you end up in some sort of settlement. So this is something that seems totally boilerplate and totally legalese, but it is very important to get it right, and it's not too hard to get it right. So just make sure that you're putting that effort in early. Go to the next slide.
Yeah, and then we wanted to dive deeper into what personal information is, because ultimately privacy policies cover not just any kind of information, but personal information. But the definition of personal information can be counterintuitive at times. And also it's a definition that's really been evolving at this moment. So to provide you with a brief overview, personal information doesn't just include a person's name, but anything that can be used to reasonably identify a person, such as an address information, telephone number, and even IP addresses. So in the past, IP address was considered non-personal information, but that has shifted in the past 5 to 10 years, and now it's considered personal information by state and federal regulators. So that's also something to keep in mind, that it is also personal information. And then there is also a special category of personal information called sensitive personal information, and that includes things like gender identity, age, sexual orientation, employment status, religion, and certain health information. These are considered sensitive personal information because it often includes immutable personal characteristics, or it has huge ramifications if fallen in the wrong hands and can be used as a way to discriminate somebody. So more obligations attached to this kind of sensitive personal information. So for example, California has this privacy law called California Consumer Privacy Act, and they provide a right to consumers to limit how companies can use sensitive information. So that's also something to keep in mind. And if you are subject to this California law, which Hale will talk about thresholds a little bit more later, but if you are subject to it, then you have to offer this right, and you have to disclose in the privacy policy that you do offer this right. So that's also something to keep in mind. And lastly, we wanted to cover what is not considered personal information. So B2B information is generally not covered in the privacy policy. And by B2B, we mean registration information of your company's customer. And that information is typically governed by the contracts between the parties as opposed to in the privacy policy, which just covers personal information of the individuals. And then next slide, please.
All right, so just wanted to cover, kind of put this a little bit more concrete terms about the types of personal data that may be applicable here and like how that fits into the privacy policy. So you collect inevitably personal information unless you're, affirmatively trying not to. You're going to collect a lot of personal information from a number of different sources, depending on what you're offering on your websites, apps, and services. So you may communicate with users or your customers or clients or potential customers and clients for marketing, advertising, other sorts of services. So this could be when a user contacts your customer support team, they're having an issue and they have a web form to include. They need to add their name and add email address, phone number, that sort of thing. If you offer a forum, or if you post testimonials by a user of your services, or any other information that a user affirmatively provides to you. You can enable users to open and maintain an account on the website, whether that be from a social media profile, or if you have, the user has a cloud account where they store documents and they need access to it, or some sort of customer registration to use a service on your site to like sign up for something, add a calendar. If you're transacting business on the site, if you make a purchase, if you make some sort of reservation, if you're running analytics on your website or on your app, for example, like Google Analytics, LinkedIn Analytics, HubSpot, there are a number of different ways that you can track usage. I will say, if you are not a web developer and you're using a third-party vendor to create your website or app, like Square, one of these others, Wix, they typically have analytics built in. And then on top of that, you can layer in other sorts of analytics, which is pretty helpful, but does constitute collection of personal information. And then direct advertising. So if you're using Google AdWords or you're doing targeted advertising on Instagram, something like that, you will get conversion data about individuals, even if it is aggregate. That is a use of personal information. So these are all sorts of things you should be thinking about. How are we collecting personal information, in what ways, and really kind of have a brainstorming event to put that on paper and make sure that you're covering all those different avenues. Next slide.
Yeah, and then the key topics to address in privacy policy. So Hale briefly touched upon this, but it's always good to include what may happen to the personal information that's collected in an event of a sale of your business or bankruptcy. So there's a really famous FTC enforcement case where a company called ToySmart represented in the privacy policy that they would never sell or disclose customers' information. But then they ran into some financial troubles and then tried to sell all of their assets in the bankruptcy court. And this asset also included customers' personal information. And they had to settle with the FTC. The FTC was not very happy with this privacy policy because they basically broke this promise. So we always advise our clients to include information that it may be shared in the context of M&A or due diligence or in the context of bankruptcy proceedings. And then another section that is applicable if you're subject to certain privacy laws is that state privacy laws also require you to offer various rights. I briefly touched upon the right to limit sensitive data, but it also includes things such as the right to access information that you collected, and then right to correct certain pieces of information, and also the right to delete. And in the privacy policy, the law requires you to disclose how consumers can exercise that right through you. So that's another key piece of disclosure that should be included if you're subject to this law. And then when you make a material change in the privacy policy, you must always notify the consumer of those changes. And it doesn't include just any kind of changes, but material changes to the privacy policies. An example of a material change may be things like, in the past, if you said that you're not collecting any sensitive information, but if you began to collect sensitive information, that can be an example of material change. Or another one can be something like, if you didn't engage in targeted advertising, but now you do engage in targeted advertising, that's also a material change. So material change are things, so changes in practices that a reasonable consumer wouldn't normally expect. So that's something to be aware of. So an example of non-material change would be something like, well, you used to collect email addresses when you are sending out newsletters, but you are no longer offering newsletter services. That is something that's a little bit minor, so wouldn't be considered a material change and something that is within the expectation of a reasonable consumer. And next slide, please.
All right, so they've said the CCPA name a few times. This is just to kind of put you on notice of what some of these threshold requirements are, see if they apply to you. If you have over 25 million in annual gross revenues, if you buy, sell, receive, or share personal information of 100,000 or more California consumers. So that would just be residents in California and not nationwide or globally. Or if you derive more than half of your annual revenue from selling personal information. That last one may probably apply the most to small businesses, probably still not applicable to most of the people in here, but just to kind of give you a heads up. Thresholds are similar for the other comprehensive state privacy laws. This is not to say that the CCPA and the other large comprehensive privacy laws are the only state requirements you have to meet. There are other like very specific state privacy law requirements. So this is why this is just a primer. And, you know, to the extent that you grow and you have larger legal spend, you can talk to a lawyer and make sure that you're actually making sure that you're hitting all of the major laws to de-risk as much as possible. So another major threshold is if you start to provide services or if you target individuals in the European Economic Area, the EEA, which is essentially the EU with a few other countries as well. Once you are targeting individuals in the EU and you are processing their personal data, then you will be subject to the General Data Protection Regulation, which is the comprehensive privacy law in the EU. They are much more sophisticated than the US in terms of privacy, at least at a federal or union-wide level. So there are a number of compliance requirements that you have to meet. It's very difficult to fully comply with the GDPR. To the extent that you are going to be doing business in the EU and processing EU personal data, you should be cognizant of that and do as much due diligence as you can. But we will not talk about those specific requirements because they are very complicated, and we are a U.S. counsel here. So I'm just flagging that for right now. A few other privacy laws just to close out this segment that we want to raise. One is my favorite law, the Health Insurance Portability and Accountability Act of 1996, aka HIPAA. It's another very complex and often misunderstood law. To the extent that you process or collect, use, disclose health information, that does not necessarily mean that you'll be subject to HIPAA. HIPAA only applies to two entities, covered entities, and their business associates. A covered entity is essentially a healthcare provider that bills insurance or a health insurer. And a business associate is their service provider that processes personal information on behalf of a covered entity. If a user's health information does not derive, essentially, this is kind of broadly speaking, but if a user's health information does not come from a health insurer or a healthcare provider that bills insurance, then that information is probably not going to be subject to HIPAA. So do not just assume because you're dealing with health information that you are subject to HIPAA. That does not mean that you fall through the cracks. The Federal Trade Commission in particular has been taking a much stronger approach to health information generally. So from health-related apps and websites that deal with kind of health information that you provide to a website, that like a user provides to the website, or that's collected from a wearable device. That is more and more often being regulated pretty stringently by the FTC. So again, a very important reason why, if you're in that industry, you should have a very solid privacy policy, because they are going after companies like that. And then Yeji, if you want to talk about COPPA.
Yeah.
Sorry, I had a quick question about the HIPAA. I am wondering for health information, what examples of health information would, I guess, require to kind of be observant of HIPAA. I'm kind of thinking someone opening a gym, or needing to kind of have information, or wants to do a personal fitness coach, that kind of thing. Would they need to know certain health information, and would that apply for some of this some of these privacy laws and regulations?
Yeah, sure. So all of those examples that you just provided, which are great examples, would not be subject to HIPAA. So if you are a fitness coach and you need information about my heart rate and my medical history, my physician in case of an emergency, that sort of information, that is all information that I am providing to you personally. So that information derives from me to you. So that information is not coming from a healthcare provider or a health insurer directly. So that information is not subject to HIPAA. Even if I authorize my physician to disclose that information to you, that would most likely be pursuant to a HIPAA authorization, that would still not be subject to HIPAA because of the authorization requirement. So in all likelihood, unless you're working with a healthcare provider or a health insurer directly, or if you're providing kind of a more sophisticated software or an app or something where you're actually getting what's called protected health information from a healthcare provider or a health insurer, that information will not be subject to HIPAA. So you don't need to worry about HIPAA, which is great because it's very confusing and hard to deal with. That being said, to the extent that you're getting any sensitive health information, you need to be very explicit about how you're collecting, using, sharing that information in your privacy policy, and generally know consent requirements, you know, to the extent, especially to the extent that the user is providing that information to you. To the extent that you're getting any sort of sensitive health information from a third party, or from any source where the user wouldn't expect it, then you're kind of getting into some territory where it would definitely be worthwhile to engage a lawyer to talk through that, because misuse of that data can be fairly serious.
Got it. Thank you so much, Hale.
Okay, so before we finish this segment, I'll briefly touch upon the Children's Online Privacy Protection Act. So it applies to any website or online service directed to children under age 13 or knowingly collects information about such children. So the first part, directed to children, means intentionally that the service that you're providing is targeting children, but knowingly collects doesn't always mean intent. So it means that you're directly aware that a child is using your service. So for example, let's say that your website is collecting birth dates, which we advise against. This is not legal advice, but as a general practice. And let's say some users say that they're under 13, and that's like one way to be directly aware that a child is using your service. And in such cases, you're still covered under COPPA. And then the best practice is to make sure that you link the privacy policy in a very prominent and clear place on your website, and make sure that you receive parental consent to collect personal information from children, and to provide clear opportunities for parents to review that information. And I think that's it for the privacy part, unless you have any other comments. Yeah.
That's all. Thank you.
Thank you, Hale and JG. So at the end of the presentation, we thought it would be helpful to provide like a quick overview of the different forms of IP and how companies can manage and protect their IP from the start. So we'll start with copyright. Copyright is basically everywhere. It protects original works of authorship fixed in a tangible medium of expression. So this could include paintings, photographs, musical compositions, sound recordings, software code, books, movies, and so on. And there are two basic requirements that need to be met. First, the works must be original work created by a human author. And second, the work needs to be fixed in a tangible medium. So for example, if I write it down on a piece of paper that is sufficiently fixed, or if I type into my laptop, or record it if it's a musical work. The owner of the copyright work would have the exclusive rights to make copies of the work, distribute the work to the publicly display the work, or publicly perform the work if it's a musical recording, and prepare derivative works. So a derivative work is basically a work based upon one or more existing works, such as a translation, motion picture version of a book, sound recording, or abridgment or condensation, or any other forms in which a work may be recasted, transformed, or adapted. So for example, making a film version of a popular book would be preparing a derivative work, or modifying an image or painting to include additional elements. Under the Copyright Act, the copyright owner has the exclusive right to prepare and authorize others to prepare derivative works based on a copyrighted work. In other words, anyone who would like to make derivatives need to have the copyright owner's permission or authorization. Copyright protection lasts for the life of the author plus 70 years. If a work is created for a company, then it lasts 120 years after creation, or 95 years after publication, whichever is less. There's really no formality for copyright protection beyond the fixation requirement. Protection exists upon creation of the work, with original ownership vested in the author. But ownership of copyright can be transferred, or certain rights can be licensed to a third party. Registration is not required, but it could enhance the protection in the work. So, and in the US, registration is necessary to enforce the exclusive rights through litigation. a very important concept under copyright is the works made for hire doctrine, which is basically an exception to the default rule that copyright vests in the original author of the work. So for example, works made for hire include works created by an employee within the scope of his or her employment. And for those works, the employer or the company will be the copyright owner of such works. This doctrine also applies to certain independent contractor relationships for certain types of commissioned works. But note that the categories for commissioned works are very narrowly defined. For example, it covers work specially ordered for use as a translation or as a part of a motion picture or as an instructional text. So most of the works done by independent contractors will probably not fall into these narrowly defined categories. And to make sure that you own everything created for you, the best practice is to have all employees and contractors sign a written assignment to transfer IP ownership to you or to the company, rather than rely on the works made for hire doctrine. A trademark is any word, name, symbol, phrase, color, or logo, or any combination of them that identifies the source of a product or service. When adopting a new trademark, the first thing to make sure that it is available for use, meaning that it's not already used in commerce by another company for similar goods or services. Once that is established, then similar to copyright, there are two basic requirements to obtain trademark rights. The mark must be in use in commerce and it must be distinctive. So for the distinctiveness requirement, a mark can fall into basically 4 categories based on the relationship between the mark and the underlying product. So fanciful or arbitrary marks are given the highest degree of protection. They bear no logical relationships to underlying product. For example, examples for fanciful marks are Kodak or Exxon, which are made up words. And an example for arbitrary mark is Apple for computers. It is arbitrary in the sense that it bears no logical relationship to the underlying product, which is computer. A suggestive mark is a mark that evokes or suggests a characteristic or of the underlying product. Some exercise of imagination, so to speak, is needed to associate the word with the product. So for example, Netflix is suggestive of the internet streaming services. A descriptive mark is a mark that directly describes the quality or a characteristic of the product. So for example, Holiday Inn or US News. They tell people something about the product, but unlike fanciful, arbitrary, or suggestive marks, there's an additional hurdle to be cleared before descriptive marks can have trademark protection. Finally, a generic mark is a mark that describes the general category to which the underlying product belongs. So for example, computer is a generic term for computer equipment. And those generic marks are entitled to no protection under trademark law because the words are simply too useful for identifying the product, or sometimes they are the only way to identify a product. If you are the owner of a trademark, then you have the right to prevent others from using confusingly similar marks for similar products or services. The duration of a trademark protection can be perpetual, but it can also be lost. So there are, for example, trademarks can be deemed abandoned when you discontinue the use of the trademark in commerce with an intent not to resume the use again. Trademark protection can also be lost if the trademark owner engages in naked licensing or improper licensing, where the owner fails to exercise adequate quality control over the licensee's use of the trademark, such that the trademark no longer represents the quality of the product or service that the consumer has come to expect. Protection for trademark can also be lost through the so-called genericide, where the trademark becomes so popular that people start to use the trademark to denote the broad type of product and not a specific source or manufacturer. So for example, escalator or aspirin or dry ice, they were all once protected trademarks owned by some companies, but they have subsequently lost their legal protection as a trademark because they become the common name of the relevant product or services. So in the US, there are two ways to establish rights in your trademark. The first one is under state common law, which is awarded to the first to use the trademark in commerce in connection with a product. There is no registration required, but protection is limited to the geographic area in which you sell the products and in any area where the reputation of the mark has been established. The other way to acquire protection is provided under federal law, and you need to register the mark with the US Patent and Trademark Office. But note, for the federal registration, existing use of the mark in commerce is actually not required as long as you can show a bona fide intent to use the mark in commerce in the future. There are some significant advantages of registration of your mark with the PTO. So for example, registration, if issued by the PTO, it serves as nationwide notice of ownership and use of the mark. It also prevents others from registering similar marks for similar goods. Just a caveat, the trademark right is geographic. So the above laws only apply in the US, and registration with the US PTO will not give you trademark rights in another country. And the last one I will cover in this presentation is trade secret. It protects non-public information that has independent economic value and is subject to reasonable protection by the company. The subject matter for trade secret protection is quite broad. It covers anything from information formula, patent, customer list, research plan, programs, computer programs, process, device, etc., or prototypes of your product. And there are three basic requirements. First, the information need to have independent value, but the bar is pretty low for this requirement. And secondly, it has the information need not to be known to the general public. And third, which is probably the most important one because it's sometimes forgotten, the company needs to use reasonable efforts to protect its trade secrets. So reasonable efforts include physical protection and contractual protection. So for example, an example for physical protection could be putting your sensitive documents in a vault or restrict access to the information to only a few key employees within your company. And contractual protection will involve signing, for example, signing non-disclosure agreements with any third party before disclosing any confidential information and trade secrets to such third parties. So if a piece of information qualifies as a trade secret, then you have the right to seek remedies for misappropriation of your trade secret by a third party. For example, if the third party wrongfully takes or uses your trade secrets. Duration of trade secret protection could be perpetual, but the same as trademark protection, it can also be lost if the secret has been published by some third party, or it has without like any wrongdoing, or it has been generally known to the public, or if the company fails to adequately protect your trade secret. This is just a comparison table for different forms of IP. We didn't really touch patents since it's probably less relevant here, and the laws around patent protection and patent application are more nuanced and more complicated compared to the other three types of IP. So if you're thinking about filing a patent application, or if you have any questions related to patent, then it would be a good idea to consult a patent attorney. So finally, I see we're running short of time, so just want to quickly run through some of the high-level tips on how to protect the IP of your company and how to manage third-party IP.
Quick question, Christina, before you move. There is a question in the chat. Does a food recipe qualify as a formula? Can a recipe be legally protected?
Yes, yeah, of course. So food recipe, if you keep that as so you probably want to keep that as a trade secret if you don't want to other party to have access to that. So yeah, definitely. But you don't want to make sure that you restrict access of your to the food recipe only to the employees that that need to know the recipe. And but yeah, it definitely can be protected. So for example, the secret formula, which is of Coca-Cola, it's a classic example of trade secret.
Just another quick question. I know there was recently for like this business in Berkeley with the mochi muffin and related to like trademark. What are like some concern or considerations with like doing food related trademarks and kind of thinking about how that really applies for that?
So can you repeat the first? I didn't quite get the first part about
Oh
that.
yeah, just some like considerations for like food related, like kind of similar to the question in the chat, like just thinking about if you are selling a food product and you're thinking of trademarking, like what are some considerations for trademarking a food product?
Sure. So I think the first one is that you don't want to use generic terms for your trademark. So for example, you can't really trademark the term apple if you're selling apples. And so if you're like selling muffins or like some other food product, you really want to choose a name that is not generic for the type of the food you're selling. And also, but beyond that, I think that if you want to use your name, some restaurant or some food chains like to use surnames in their trademarks, and just make sure that you have the appropriate right to use, because the surname or other people's name for your trademark, because if you are not the person, then you probably want to have publicity or privacy permissions from the other people with the surname. And other than that, I think it's food trademarks are same to other trademarks. Or does it answer your questions, or is there like any particular concern?
No, I think that was great. Thank you.
Yeah, sure. Yeah, so just finally, just quickly running through some of the high-level tips on how to protect IP. So first of all, just know that a single product may utilize more than one form of protection. So for example, if you have a software program that could be that you could have copyright in the source code and the display of the software program, and the source code can be kept as a trade secret, and also you can have a trademark protection on the name of the software program. To manage, so when you first start a company or a business, it's crucial to have all the founders and other contributors assign all their IPs in whatever they have done for the company to the company via a written assignment. So this will be the company's initial IP assets. So for example, if you have drafted any business plans or source code or computer programs or secret a recipe for food, then those IP and those should be assigned to the company. And also all employees and contractors will likely create IP for the company. So it's just crucial to have a valid IP assignment in writing. In addition, for employees, you also want to review their agreements with their prior employers to make sure there's no restrictions. For example, some prior employment agreement may include a non-compete restriction for their employees. And also make sure that employees and contractors don't use confidential information or resources of their former employers when they're providing services to you. If you include any open source software in your product, then it's important to document all the open source software and libraries that you used and what licenses are associated with them. And also, business oftentimes depend on IP owned by a third party for running their businesses, and you want to make sure that your company has all the necessary rights to use such third party IP, either through a licensing agreement or maybe a waiver from a third party. So a little bit more on third-party IP. Generally, it is a good rule of thumb that a person or entity may not use the IP of others without a license or permission. And just because, I really want to stress that just because something is publicly available online doesn't mean it can be used without permission. So for example, you can probably find a lot of images by searching on Google, but it doesn't mean that you can use those images freely without permission. And some of them, or many of them, are still protected by copyright. And then for copyright, only display content on your website or app that you create or your employees create or independent contractor create under work for hired agreement or with a written IP assignment. And don't use a third party's IP or copyrighted material without a written authorization. If you allow users to post content to your website or app, then you probably want to include a DMCA notice and takedown procedure in your terms of service. For trademarks, it's similar to copyright. Do not use third-party logos without permission. But there is a narrow fair use principle that like exception that applies. So for example, you can make references to other brand generally, like compatible with Apple products. But I would use that with caution. It's really just for references only. Yeah, so since generative AI tools are such a big thing right now, so I just want to quickly touch upon some of the key considerations if you're considering using generative AI tools such as ChatGPT or DALL-E or Stable Diffusion. Unless you have a separate negotiated license agreement with the suppliers of the third-party tool, then you should assume that confidentiality will not be maintained for any information provided to a third-party generative AI tool. So for example, those information would be accessible by the supplier of the generative AI tool, and also those sensitive information could be provided as output to other users of the generative AI tool. And also any attorney-client privilege would be waived if you provide anything to the generative AI tool. If you provide, for example, a client, if you provide a legal advice or any communication with an attorney to a generative AI tool, then you should assume that attorney-client privilege is waived. Also, it should not be used to aid or perform any legal work, because the output of the generative AI tool could be like not very accurate, and they are not very good at citing sources for their output. And for patent, and if you're thinking about register patent or have copyright protection for the output, then it's necessary to note that content produced by generative AI tools, they're not patentable or copyrightable. And so if you want to have copyright in that, then you have to make significant modifications to that so that you are the author of the work and not the AI tool. And also, if you're thinking about using generative AI for your business, whether internally or externally, then you should have internal policy regarding the use of generative AI tools. So for example, how employees can use those tools and for what tasks, and what information can they not provide to the tools. So that's all we have. Yeah, and just a reminder that these materials are offered as an education and learning experiences. This is not a substitute for obtaining legal advice from an attorney, and review of these materials does not create an attorney-client relationship. Yeah, I think we can open up if there's any questions.
I'm not seeing any questions in the Q&A or the chat, but thank you so much for all the presenters today to supporting our work and offering all this information. It was amazing information that I think will be really relevant to our small businesses. If you have additional questions, feel free to join our free virtual legal clinic. Nicole sent that information through the chat. We do have limited spots, but our next clinic is Thursday, May 25th from 4 to 6 p.m. and the link is in the chat. Yeah, we would welcome any additional questions. If you have any e-commerce questions, intellectual property questions, that are really would apply to your specific business, we welcome that your registration to our clinic. We also have one coming up in June. We do have a monthly clinic. So yeah, thank you so much to Wilson Sonsini for all the information and for your time, volunteering your time today. Yeah, I'm going to go ahead and end the webinar, and thank you again to all the attendees as well. I'll go ahead and send the clinic link again. I think it looks like someone is not able to see it. And we'll also follow up by email with the recording of the webinar as well as the presentation slides. Thank you. Have a great rest of your day. Bye-bye.